Hi, good afternoon, good morning, or good evening, depending on where you are in the world. My name is Ana Cortes. I'm a researcher at the CMI UIB Center on Law and Social Transformation, and I would like to warmly welcome you to this Law Transform webinar. Today, we will talk about Repeal abortion crime, a new path in the fight for legal abortion in Colombia. The Center on Law and Social Transformation aims to understand through research and dialogue how and to what effect rights and law are used as tools for social change. Law Transform is a collaboration between researchers and students at the Christian Michelsen Institute and the University of Bergen, and has research affiliates in the US, India, Latin America, Africa, the Middle East, and Europe. I encourage you to check out our webpage and follow us on Facebook and Instagram for information on research projects and upcoming events. This week, for example, in the following days, we have 2 other webinars. Please note that this event is being recorded and is going to be published online afterwards. I would like to let you know that you can ask questions using the Q&A throughout the whole event, and Siri Gloppen, our director, will ask them to the panelists when the time for the questions come. Si alguno de vosotros prefiere hacer preguntas en español, puede hacerlo y las haré a las invitadas. Hvis noen foretrekker å spørre på norsk, det mulig, og Siri kan oversette spørsmålene til gjestene. So today we have as panelists Ana Cristina Gonzalez Velez, Ana Maria Mendez Jaramillo, Maria Nardila, and Siri Gloppen. Ana Cristina Gonzalez Velez is going to start our talk today. Ana Cristina is a renowned researcher, activist, professor, and international expert in the field of health and sexual and reproductive rights. She is a medical doctor from UPB and holds a master's degree in social research and health from the CEDES in Argentina, and a PhD in bioethics, applied ethics, and collective health from Fiocruz Foundation in Brazil. So, looking forward to hearing from you, Ana.
Thank you very much, Aniña. I think Anja is going to help me with some slides that I will use to support my presentation. I'm very happy to be here sharing with you this webinar. I'm very pleased to have Siri Gloppen commenting on our legal mobilization effort, which we hopefully will win very soon. Could you please pass the next slide, just to give you some idea of the environment of our efforts, and the next one. This is how I've organized my presentation. Those will be 3 very short parts during my presentation. The next, please. And I will start with some background information. Anja, the next, please. I'm a co-founder of La Mesa. La Mesa is a feminist organization that was born in 1998 with the aim of decriminalize abortion. You can visit our website. I cannot open it right now because it doesn't work when you are presenting in Zoom. And during 2006, as I imagine all of you know, the Constitutional Court of Colombia decriminalized abortion in 3 circumstances, just in a very briefly way to say it, to protect the health or life of women in cases of rape and fetal malformation, and recognized the right to abortion. So at that point, La Mesa decided to fight for the implementation of that decision with the idea of produce gradual changes. So we made many efforts, just like other organizations. As you will see here, this is a collective effort to advance the implementation of those 3 legal indications or exceptions. But I want to emphasize in 2 main strategies. One is the follow-up of cases of women that have experienced barriers along all these years when they try to access to safe and legal abortions. And the other one is the production of expert knowledge on the exceptions, and in particular, the health and rape exceptions. The process of producing expert knowledge, allowing for a bigger advance in access to legal abortion, where the health exception became the first exception for legal abortion in the country. It came to a turning point when we tried to broaden the interpretation of fetal malformation in a way consistent with the human rights framework, because that confronted us with the resistance to this exception of the movement of people with disabilities, and was a turning point for us that had already started to see the limits of the exception model. Each of these links can be visit for you. We are going to share this presentation, and those are articles and papers that have been published and related to the barriers and the production of expert knowledge. Please, the next slide. So in terms of the limits to the indication or exceptions or grounds legal for abortion model, the first thing is that we realize that exceptions do not correspond necessarily to women's reasons for abortion. For example, we have an indication that is non-consensual insemination, and I can ensure you no one women in Colombia have never asked for an abortion under that exception. We've also seen that barriers to access are maintained, even increased, and supplemented or aggravated in times of pandemic. But we've also seen that criminalization has increased. Some of my colleagues will talk more about this, but I can, for example, let you know that 73% of lawsuits have been done by health institutions. We know that there are almost 5,000 active cases in the General Attorney Office in Colombia, and we have 340 convicted persons. The next one, please. So I also have to say that, on the other hand, the public opinion environment in Colombia has changed, and today 61% of the population at odds with prison, but also a conservative mobilization has tried to block access to services and return to total penalty. They have maintained its activity, but it has increased during the last year. So it's been 14 years and many sentences, making it possible to assert that today in Colombia, there is a real fundamental right to abortion, this being the status given to it by the Constitutional Court. However, by coexisting with the crime of abortion in the penal code, a deeply ambiguous situation has been created for those who provide services, those who need an abortion, and even for the public opinion and society itself. Crime then appears as a structural barrier and is at the basis of a stigma. So as a consequence, many times we see fewer providers and more conscientious objectors or even obstructors of the provision of services. Please, the next. So that's how we came to Just Cause. This is a very brief story of Just Cause. So faced with that scenario that I have described, at La Mesa, we made the decision to return to our goal, which is to fight to decriminalize completely abortion in a broad sense. And that is why we started to build and create Just Cause, a movement that aims to repeal abortion crime for the penal code. But for us, decriminalizing involves more than eliminating punishment. It also involves eliminating the use of states' punitive power in any of its forms to limit the exercise of women's reproductive rights. We also think that it involves destigmatizing abortion, decriminalize it socially, and liberalize it according to the reasons each woman has to carry it out without being criminalized for it. The next one, please. So we decided to reopen the debate after 13 years of being playing by the rules of the game proposed by the Constitutional Court, because those rules didn't solve the problems of access and legitimacy in the face of abortion. We also agree on some premises for public debate. For example, we agreed to appeal to factual aspects, to build new information from empirical and scientific evidence, to express our own views without misinforming, manipulating, or distorting, because we wanted to be different from the conversation that have been proposed from the right-wingers side, and to honestly construct and present ideas. So, in other words, our voice is a collectively constructed voice. And the next one, please. In terms of the organizational process, some of organizational elements are similar to those that we promoted in the process of building the interpretation of the exceptions, but with a longer term and broader stance. So to build a movement and to produce a public conversation, allowing us to argue that the crime of abortion is ineffective, counterproductive, unfair, and so on. So we establish a larger group, which is compounded by people who represent diverse voices, backgrounds, and trajectories. That group is formed by more than 90 organizations and 150 people. And we also agreed on a strategy with 12 areas of action that were defined by us. The next one, please. So we've been more focused in 5 or 6 of those 12 areas of action. The first one is the production of arguments. You can consult here text with a substantiation of the arguments, and also 90 arguments summarize the other text. We also decided to do pedagogical work with different audiences, like, for example, media, opinion leaders, politicians, human rights groups, networks of women beyond abortion, congressmen, women's groups, and opinion in general, because it is a constant and thoughtful long-term work. But we've been also doing analysis of the junta, communication campaigns, production of political messages, new research, like, for example, the research around criminalization, social mobilization, and we also have a legal strategy with different actions under that line. So we've been promoting technical debates, for example, with experts in constitutional law. We've been working with the Criminal Policy Committee, which is a committee very important in Colombia that has a lot to say around the crime of abortion. We designed a bill, our ideal bill, in case there is a place or a space in the Congress where we can present that bill with some congressmen or women. And we also are doing pedagogical work with law academics. And we also consider national or international claims. The next one, please. And that's how we are now in this juncture, what we call the opportunity. And in the early 2020, the Just Cause movement was launched after almost 3 years of prepare the arguments and doing some pedagogical work with opinion leaders. And we did it to begin a public debate on the need to eliminate the crime. We had no plans to make the claim just beginning the launch of the movement. So we were working in that media strategy that was also carried out, but it coincides with some critical facts. And that's why in September 2020, we filed the lawsuit that it's going to be discussed later from my colleagues. And I just would like to say, to finish this background and very brief story of the Just Cause movement, that the reason by which we are fighting for this to repeal abortion crime is that the penalty around abortion is structured around the protection of fetal life and not the protection of women's lives. And from there, problems arise, like, for example, stigma. And that's why we consider that the crime is the structural barrier that is in the basis of all this conversation. So the starting point that has been put in the public debate is that abortion crime has limits according to the fetus and not according to the needs and value of women's lives. So in a way, this crime tells us that women's lives are less legitimate, and then policies are informed by that lesser value assigned to women's life, being their biolegitimacy lower than the biolegitimacy of the fetus. I will cut here because I hope we will have time for questions. Thank you very much.
Thank you. We thank you very much, Anna, for such an enlightening presentation. And next, we are going to hear from Catalina Martinez, who is Colombian feminist activist and the regional director for Latin America and the Caribbean at the Center for Reproductive Rights. And she holds master's degrees in international public management from Sciences Po Paris and international law from the University of Panthéon-Sorbonne. So please, Catalina.
Thank you, Anna, and good morning and good afternoon to everyone. So based on the analysis that Ana Cristina has already presented, I will refer more specifically to the strategy around the case for unconstitutionality that is going to be decided by the Constitutional Court in Colombia, and particularly I will reflect on the political and legal context we took into consideration to conclude the feasibility of this strategy that Ana Cristina has presented. So I will divide my intervention into parts. I will first address why we have decided to choose the court instead of going to the Congress, to later briefly explain why, after analyzing the context of the implementation of the legal grounds to access abortion in Colombia, we have concluded that we really needed to ask for the decriminalization of abortion to guarantee women's access to reproductive rights. So first, why the court? So as Ana Cristina said, in 2006, the Constitutional Court established three grounds in which abortion is not considered a crime. And I have to say that since then, the court has developed jurisprudence considering abortion in those cases as a fundamental right and establishing obligations to authorities to guarantee access. In that sense, in these 14 years, the Constitutional Court has decided more than 20 cases, reinforcing its standards in the matter without any rollback. In these cases, the court has determined a series of guarantees to protect the right to abortion. I will give some examples. For example, the court has established a general prohibition of practices that create barriers, such as unnecessary medical boards, or the court has established that there is no need for a victim of sexual violence to file a complaint to access the service, or the court has also established rules to the adequate exercise of conscientious objections, among many others. So what I want to say with this is that the court has proven to be an ally on these issues by consolidating these protections around the right to abortion that are the ones that have been the basis for the public policies and medical protocols we already have in the country to access the service. Something that is very important also to comment here is that some of these cases were brought before the court by attorneys that were looking for retrogressions on the right that women have already achieved in the country for their reproductive autonomy. For example, some of these cases presented before the court were looking for an absolute protection of life from conception, or in other cases, the objective of the petitioners was to eliminate the 3 grounds that were established by the court in 2006. Or others were looking to establish limits for the implementation of the grounds, such as, for example, restrain the exception of risk to health, leaving out of it the affection to mental health, or the implementation of a gestational limit to access to a procedure in the 3 legal grounds. And I have to mention that for accessing abortion in the country today, under these exceptions, there are not gestational limits. So all these efforts have failed throughout the years. Instead, the court has established that even if there is some level of protection recognized to life in gestation, it cannot be considered absolute, which means that it cannot result in a total ban on abortion. And in the same sense, the court established that it is not possible to admit any limitation to the exceptions already recognized, considering them the minimum constitutional protection that should be guaranteed by the state. So in addition to this, in the most recent decisions that the Constitutional Court had taken, it began to be known in the media and in the movement that several judges were not only against limitation on the right to abortion, but were so concerned about the barriers that continued to prevent its implementation that they even proposed the court should admit access to abortion in the first 14 weeks at the woman's request. So although this position did not achieve the majority in the court, we knew that this is a position shared by several judges, which meant for us the possibility to propose advances to the court beyond the grounds already recognized in 2006. On the other hand, Congress has not shown to be a favorable scenario for progress in this area, even when on several occasions the Constitutional Court itself called the Congress to do so, or even when the feminist movement in the past presented 9 bills to advance in this sense. During all these years, there have been no initiatives that regulate the right to abortion, and have been proven on the contrary. Several legislative initiatives have been presented seeking to limit this right, in clear contrast to the constitutional jurisprudence that we have already explained today. So we also have to say that the current composition of the Congress shows a conservative majority, and there have been several recent proposals to limit abortion, including the creation of a pro-life commission inside the Congress. So I will pass to the second part of my intervention, and I have to say that even with the progress already made in constitutional jurisprudence on other regulations, the implementation of the right to abortion still has many difficulties. Organizations such as La Mesa, as Ana Cristina has explained, had accompanied more than 1,000 cases of women who face barriers, obstacles, and even bad treatment when looking for the procedure. After almost 15 years of attempting to implement the grounds established by the Constitutional Court, it became clear that the fact that abortion remained a crime outside of those grounds creates great difficulties to provide effective access to that service, including under the legal grounds that we have mentioned. And this is for many reasons, and I will briefly explain some of them. First, the crime of abortion creates a stigma and fear that affect both women who need the procedure and health professionals that provide it, generating barriers. And women have fear because they are being criminalized even today for this crime, and even when they look for the service under the legal grounds. And I have also to mention that these barriers are more present in rural areas, where usually women and girls have less access to health, which also demonstrates an unequal access to abortion services in the country. And taking, and there are many other barriers that we can explain later in the conversation, but I want to finish my presentation saying that taking into consideration these barriers that are faced by women in the country to access abortion, even under the legal grounds, and taking into consideration also the analysis of the context we have made, for example, that at least 4 or 5 of the 9 court judges had revealed that they were open to studying possible advances, we decided to file the case looking to eliminate the crime of abortion from the penal code. And we truly think that the success of the strategy is based in any case on 2 reasons. First, that we have an innovative and sufficiently mature arguments to provide grounds to the court for an advancement, and Ana Maria will explain later this. And also the fact that Causa Justa is a movement of at least the 91 organization and 134 activists that were the ones that signed the lawsuit. But we also know that after that, with the time, others have joined the cause as well. So as Mariana will explain later, this movement is not only about a legal strategy, but it's about advocacy comes and social mobilization. And today we can firmly say that we have a strong political and social support from all over the country to this cause. And I will let my intervention there so that we can hear my colleagues, and of course we can develop all this in the conversation. Thank you so much.
Thank you very much, Catalina. It's very interesting for us to get to know more about your strategy. And our next panelist is Ana Maria Mendez Jaramillo. She holds a bachelor's degree in law from the Universidad de los Andes, where she is also a PhD candidate. She holds a master's degree in human rights and democratization from the European Inter-University Center for Human Rights and Democratization, and is also a specialist in constitutional law from Pontificia Universidad Javeriana in Colombia. So please, Ana Maria.
Thank you, Ana, for this presentation, and hi, everybody. It's a real pleasure to be here. So after Catalina's analysis on the litigation strategy, I will briefly expose the main arguments we wanted to raise before the Constitutional Court. I will not go deep into each argument. We don't have the time and it will be boring. I will just divide the main arguments into what is new and what can be problematic regarding our constitutional claim. So regarding what is new, I would like to point out 3 arguments. The first one is related to the constitutional recognition of abortion as a right, and more specifically as a fundamental right. So indeed, there has been a transformation in the legal and the constitutional discourse regarding abortion in Colombia. From talking about abortion as a crime that was partially decriminalized in 2006, the court and other institutions, but mainly the Constitutional Court, transformed this language of abortion into a right-based language. So in our claim, we show that since 2010, the Constitutional Court has recognized and ratified that abortion under one of the 3 exceptions has become a fundamental right for women in Colombia. So we emphasize with research, data, statistic, and real cases that with the recognition of abortion as a right and as a crime, both doctors and women have to face the consequences of this double standard, this legal ambiguity that creates a hostile environment for the full implementation of the legal and the constitutional standards that protect the fundamental right to abortion. As my colleagues pointed, we also talk about stigma. We emphasize that if the state respects, protects, and fulfills this right rather than criminalize it, it will have an effect on reducing abortion stigma, but also on reducing barriers to access abortion healthcare. So this leads to the argument of the partial criminalization as the structural barrier that impedes or prevents the full implementation of the fundamental right to abortion, a right that didn't exist in 2006 and now it does. The second new argument is the equality-based approach. In fact, each argument of the constitutional claim includes an analysis on the partial criminalization, on how the partial criminalization has a discriminatory and a disproportionate effect on the life of the more vulnerable women in Colombia. This in terms of barriers to access abortion healthcare, but also in terms of criminalization. In terms of barriers, we brought sufficient evidence showing that the vast majority of women facing obstacles in access to abortion care are indeed the more vulnerable. Women that live in rural areas, young women, migrants, poor women. And we also link this argument with the actual context of COVID-19 crisis, where the access to reproductive health has been seriously jeopardized in our country. And in terms of criminalization, we managed to collect data from the Prosecutor General Office in Colombia. And just to draw you a picture, 97% of women investigated for abortion crime in Colombia live in rural areas. Nearly 20% were university students, 30% were high school students, and 2.7% were engaged in sexual work. 30% were victims of crimes such as domestic violence, sexual violence, or personal injury. And this is a very interesting fact. Of the total of the cases that has been opened since 2006, in less than 4% of the cases, there is sufficient information on the reasons that justify the abortion. So this indicates that the vast majority of the criminal cases are initiated without considering whether the case could have been framed in one of the exceptions allowed by the court in 2006. So as we expected, the crime has been applied and has been applied in a disproportionate and a discriminatory way against the more vulnerable women in Colombia. The third new argument is related to the constitutional right to choose an occupation and the freedom to engage in work. We introduce in our claim a new character or a new point of view, which is the healthcare providers that chooses to provide abortion care. Now, in one hand, our constitution protects the right to choose a profession or career, and the state has the obligation to provide the conditions to exercise it freely. But on the other hand, abortion crime also applies for the person that provides an abortion, aside from the three exceptions. So we argue that while healthcare providers are called by the state to provide abortion under the three exceptions, at the same time, they can also face criminal charges if they do not interpret correctly abortion law. And actually, we show the court that there exist cases of healthcare providers facing criminal charges. It's not the majority, of course, but there are cases. We also brought recent research that showed that there are doctors in Colombia that refuses to provide abortion care, not because they are conscientious objectors, but because they fear facing criminal charges. We also talk about how abortion healthcare providers are usually stigmatized, face marginalization, work overload. So the argument here is that with the partial criminalization, the state is threatened the freedom to engage to work for those healthcare providers that decide to provide abortion care. We believe that with these main approaches, we build strategic arguments because we believe that the discussion of abortion in Colombia in this stage is different. After 14 years of implementation of the judgment that partially decriminalized abortion in Colombia, we have strong reasons to say that abortion should not be a matter of a criminal law. It should be a matter of healthcare policies or public policies. So the thing is that now, after 14 years, we have more knowledge, and we believe that we managed to support each argument sufficiently in order to provide the strong arguments to the Constitutional Court. Now, I'll briefly mention some problematic things we identify in our constitutional claim. The first one is related to the application of this legal figure known as the final decision, or what lawyers call claim preclusion or matter judge. So as Ana Cristina and Catalina pointed, the judgment that resulted in the partial decriminalization of abortion in 2006 started from a claim that was raised from the Constitutional Court. So in this sense, there is an important question on whether it is possible to open a new discussion before the Constitutional Court on this same matter, or if the decision adopted in 2006 was the final decision and closes the debate into the court. This is a very formal argument, and this deserves a deeper explanation, but just we wanted to let you know that this was a concern that we took into account, and that's why we were very careful in raising innovative arguments to show the court that the actual debate has changed, and also that the legal and the social circumstances have also changed, and that this topic deserves to be discussed again, deserves a constitutional debate. And also we wanted to let you know that our claim was admitted by the Constitutional Court last year, which means that the court considered that there is a potential constitutional controversy that deserves to be discussed. Another point that might raise some fears has to do if the court decides to repeal abortion crime, but imposes additional requirements or conditions that would make it impossible for women to access abortion care. Nevertheless, in our claim, we argue the principle of non-regressions in human rights, and we are hopeful court doesn't go against its own jurisprudence, which has been clearly in favor of women's reproductive rights. And to close, the third point that could be problematic is if the court considered that criminal law is a legitimate way to regulate the matter of abortion and decide to keep it in the penal code. We fear that if this happens, this could increase the rates of criminalization of women in Colombia. So thank you very much for your time. It's a real pleasure to be here. I'll be glad to answer further questions.
Thank you, Ana Maria. It was great to get to know more about the arguments you presented. And now we would like to welcome Maria Nardila to the debate. She is a senior legal strategist, litigator, and women's rights activist with 12 years of experience. She holds a bachelor's degree in law from the Externado University in Colombia and a master's degree in international law from the New York University, the United States. So please, Mariana, the word is yours.
Thank you, Ana. It's very exciting to be here. I'm personally very passionate about using the law and the courts to create social change. And at Women's Link, where I work, we are all about using the power of the law to transform lives. So Women's Link was invited by La Mesa to join the Just Cause efforts from the start. And when the movement decided that the first legal avenue to try will be a constitutional claim against the criminal code, we were enthusiastic to put our strategic litigation experience at service. Back in 2006, building upon other organizations' years of work to decriminalize abortion, Women's Link led the litigation efforts against the total ban on abortion, which conquer the three broad grounds we have now. We are honored to receive a vote of confidence for a second time to co-lead this process. Thanks to years of hard work by many organizations, we currently have a much more diverse, broad, strong, coordinated movement. And so as you can see, Just Cause has a collective signature we are proud to be contributing to. As Ana Cristina mentioned, there was tons of expert knowledge produced since 2006 on access barriers, on criminalization, on the impact on health workers, on different types of arguments and more. Just Cause formed a group of lawyers and expert litigators, and we translated that expert knowledge into a technically strong and strategic lawsuit. Having got the case admitted is a first proof of this work on how strong it is. But that is not the whole story. In Women's Link, we use litigation as a platform for social change. We refer to this as litigation plus, and that plus is what I intend to share with you today. For those of you who are interested in it, I'm sharing in the chat a link to a publication from Women's Link that goes deep into this concept. As Ana Cristina explained, just cause is much more than a constitutional claim that we file. But that part of just cause efforts exemplifies perfectly what we mean with that plus. With this case, just cause is not only aiming to set a legal standard, that is to take abortion crime out of the criminal code, but we also want the lawsuit to contribute to shape public opinion, what Ana Cristina refers to the social decriminalization, and to bolster social mobilization by actively creating opportunities for activists and civil society to organize and mobilize around the case, and by doing that, engage and commit to our just cause. We believe that doing that plus, instead of just filing a case like any citizen could have done, enables the condition for a real implementation of a good decision and for maintaining a victory in light of any attempt of backlash, which we know it will come if we win. And this is important. Even without an immediate legal victory with this case, the conditions to get abortion out of criminal code through future litigation or other democratic avenues like a Congress Act will improve, the movement will be stronger, and the public will be better informed. And don't get me wrong, I'm a lawyer and I want to win this case and our hopes are high, but it is not our only aim. The broader aims and other strategies of just cause are equally important, and the lawsuit should be at their service. In order to achieve this, the lawsuit has a communications and a social mobilization strategy that is in line with just cause strategies. I will share with you some examples of what we have achieved so far, and we intend to keep coming achievements like those ones that I'm sharing with you. First, since the beginning of 2010 to date, and despite a pandemic and the 1,000 scandals and crises that we have in everyday Colombia, decriminalization of abortion has been constantly on the public agenda, including big media in all its forms and also in specialized top legal forums. Second, the coverage has been positive. Why I say this? Because it is using a quantitative and qualitative data. It is reaching out to diverse expert voices, so it's moving away from debates like the priest against the activists or the anti-choice politician versus the activists. Is going beyond that. It is portraying the arguments that we develop and choose to be at the center of the debate. That is the public health angle, the social justice angle, the reality of criminalization, the impact on health workers, the criminal public policy angle, and so on. Also, the vast majority of op-eds has been supportive. Third, we are a movement that is becoming better at mobilizing both physically and digitally, overcoming the challenges posed by the pandemic. It is key to highlight that the movement is intergenerational and includes the newest expressions of the women's movement in Colombia. We are also diverse in expertise. Some create digital content, others are spokespersons for different audiences, others engage new members, others call for and organize for demonstrations, etc. So with all these, right after the filing, we did a very successful digital Just Cause festival for several days, where different expressions of the movement had activities, and we connected with what was happening in other countries in the region. Also, we got to be trending topic and generate digital debate on the days that the lawsuit was filed and admitted. And in the middle of the pandemic, we have had symbolic acts before in front of the court. For example, Just Cause organized one of the stops of the march that the women's rights movement in Colombia organized around the 25th of November, which is a very symbolic date for the movement. And that march has high levels of attendance in the middle of a pandemic. Fourth, we have more and more diverse allies each time. The lawsuit was signed by a core group of 5 organizations, but other expressions of the movement and allies not formally in the movement also joined the lawsuit. We had more than 150 persons or organizations that joined from different backgrounds and places in the country, not just the capital. We also got 114 high-quality amicus curiae to support the lawsuit, giving their expert opinion from different standpoints to the court, both national and international. Among those amicus curiae, we had top law experts on criminal, constitutional, human rights law. We had healthcare professionals, indigenous women's leaders, Afro-Colombian organizations, LGBT organizations experts on the right of people with disabilities, on the rights of migrants, and local organizations from different places in the country. And last, some important opinion leaders from different backgrounds who had not spoken previously about abortion have done it, generally speaking, to support our cause. So we will keep collectively applying this litigation plus approach to this lawsuit to contribute to Just Cause purpose of becoming a movement from years to come. And I welcome your questions. Thank you very much.
Thank you very much. Thank you, Mariana. Thank you all. All the presentations were really interesting and amazing. And I will call now Siri Gloppen, our director here at Law Transform, and also a professor of comparative politics at the University of Bergen, and she's going to ask you the questions from the attendees and her own questions. So please, Siri. Thank you.
Thank you, Anna. And thank you so much, Anna Cristina, Anna Maria, Catalina, and Mariana. It was amazing. It was so interesting to hear about, in such a comprehensive way, about the litigation, about the court case and what you're presenting to the court, but also about the background, and in particular, the really, really comprehensive strategy that you have pursued for such a long time. And I think it is, I have been studying litigation strategies for so many years. And I think for me, this is really, maybe I will for sure use it in my teaching as a really super interesting example of how you systematically work to create alliances, but also to use specific strategies relating to the use of science, the compilation and production and consolidation of knowledge, scientific knowledge that is relevant in different fields. And in that way, also reaching out to communities of practice in many ways, but also how you use arts in mobilizing, how you use sort of clearly sort of rely on international as well as domestic expertise, how sort of every step of the way is really interesting to see. And I think this really advanced strategy of moving, sort of analyzing when the context is ready, moving when the context is ready, analyzing to what extent political avenues are open, to what extent the court seems seems favorable, and all of this is very, very interesting and fascinating to watch. And I will soon get to some of the questions in the chat because we don't have so much time, but I want to sort of ask you two broader questions. So one is so you're not the only ones making strategy, and you've been sort of alluding to this. If you win, there will be a backlash. Your strategy of sort of capturing hearts and mind and winning public opinion, others are also doing this. So how do you see, what are the main challenges? How are the other side responding to your different strategies? And is this sort of a risk if you win? How is this? Is there a risk that this might play into opponents? So this is one question. The other is the international dimension. So this has been such an amazing, the last few years have been really amazing in Latin America when it comes to mobilization around women's rights, around women's reproductive rights, around violence against women. And to what extent to what extent is your cause helped by what is happening in the region more broadly? To what extent does this make your work with public opinion and public mobilization easier? To what extent do you have sort of both direct and indirect strategies that are regional? So that's the second question for me. And then, since we don't have so much time, and I know you're good at taking notes, I will also sort of pose the questions from the chat, and you can choose which ones to respond to. So the first question, which is interesting because I think it's, in a way, for you probably so obvious that you haven't thought about it, but saying it. But the question is, what are the arguments for keeping abortion criminal? And do they stem from any type of religion which is deeply rooted in the culture? So that's the first question. The second is, what do you think about the role that abortion stigma within healthcare institutions may play as a barrier to abortion? For instance, from healthcare professionals who don't fully understand their legal responsibilities to perform abortion or who present their own barriers to women. The third one, which is related, do you see any parallels between restricted abortion rights and restrictions in other areas of sexual and reproductive rights in Colombia? For instance, I've talked to women who have faced resistance from doctors when asking for a sterilization. To me, this represents a lack of respect for female autonomy in the healthcare system, which is similar to that which exists in trying to access abortion. I'd love to hear what your thoughts are. Thank you. The third one, how are you able to differentiate between those who are refusing to perform abortions due to consensual objection or due to fairer repercussions? Specifically, how do you legally prove conscientious objection? And there are so many good questions, so we just have to hear them. The last one I have here is, what role have feminist activist movements or networks played in pushing for reproductive rights in Colombia? So you have talked about that, but maybe it's even more specific. So so now you have a lot of questions to choose from. And I would just like to sort of, maybe I'll give you the word in the reverse order. So starting with Mariana and ending with Ana Cristina, who was the initiator of this event and should have the last word, to answer whatever you find more interesting of the questions posed.
Thank you, Siri. On the strategies from the other side, from the anti-choice groups, so far what we have seen in the court is that they have a strategy sort of to harass the court, and like filing like unsubstantiated claims and petitions
that has been systematically rejected by the court in our case and in other related cases. So that has not been, I think, for them very successful. Actually, one anti-choice lawyer has already been started to be investigated by a law practice board for doing those activities. Really, it's not about making argument, but it's just about like delay and difficult and make the process more difficult. And I think the judges don't like that, generally speaking, and in this case. They also have like a strategy to ask people to write to the court. And I think that's I mean, it's allowed, is perfectly understandable. But also, as we are not dealing with a Congress process, but a court process, they also have to offer like substantial arguments. And there is some of that, but the vast majority of the arguments presented are not like specialized technical arguments. I think we outweigh them in the number of substantial amicus curiae presented to the court. And with regards to other things, they have been talking to the media also, as we have, but I think they have not offered like a variety of voices as we have done it. They stay like in the classical arguments of giving personality to the fetus and not responding to more profound arguments that we have been posing in the public opinion and in front of the court. And then with regards to the international dimension, I think for sure what is happening in the region is helping our cause and is connected to our cause. Like, it's not like we are like islands separated from each other. We talk to each other, we share strategies, we share concerns, etc., etc. So we are sort of riding the wave also along with other activists in the region. For example, when the law was passed in Argentina at the end of last year, there was a lot of interest from Colombian media to compare the two processes, to understand how is it different, how is it similar, etc., etc. And we have been like taking advantage of those opportunities to explain about it.
Excellent, very interesting. Ana Maria.
Okay, I would choose the question regarding what are the arguments for keeping criminalization of abortion. So, I mean, this is a very broad topic, but the main point, I think, is that the Congress has the liberty to decide on criminal matters. And Congress decided that the way to protect fetus life will be by using criminal law. When the court in 2006 decided about this claim that was raised before the Constitutional Court, the court says that this was not the only way to protect the life of the fetus, but I think it was a matter of division of powers, you know, that the court didn't want to go and say the Congress, you're wrong, you're I mean, like this thing of the democratic principle. So the court didn't want to impose a decision that might be a matter of democratic principle. So the court in 2006 says, okay, there are other ways to protect the life of the fetus, but I will leave it like this. You know, You can go to the Congress, you can talk to them, but for now, I'll leave it here. But the court, I think, leave the door open for a new discussion. So that's why we proposed after 14 years that this is the moment to talk about it again. And regarding the question about consensus objectors, in Colombia, there is the Constitutional Court has set a lot of these formal rules for doctors to raise consensus objectors. But there was a research that was held in 2015 that shows that many doctors refuses actually to provide abortion care because of the fear of facing criminal charges. So this research was held to the Constitutional Court. This has scientific evidence. So that's why we could prove it. And also because we could get to know doctors that formally are consensus objectors, but then they provide healthcare, abortion care in private clinics. So in the end, they are not consensus objectors. They fear facing criminal charges. So I would do it like that.
Thank you, Ana Maria. That's very helpful. So Catalina.
Yes, thank you, Siri. So I would like to reflect on the two questions that you made. I have to agree with what Mariana has already said about the strategy from the opposition, and wanted to highlight what our strategy is also doing very well, no? Because I think it is important, even if we have already mentioned this in our presentations, to highlight why we think what we are doing is for the best interest of the population. So I think that we need to insist with the idea that we are not only looking for a progressive legal standard, no, and that is something that is very, very important for us. We are looking to really shape the access of women to reproductive care services in the country. So I think that that's something that is very important to highlight, and how this litigation and all the strategies that are being deployed around this litigation, no, such as the ones that Mariana has mentioned in her intervention, no, communication strategies, social and media mobilizations, advocacy actions, are aimed to shape the public opinion, so that not only activists and civil society organizations, but anybody that really sees its interests represented in this fight can mobilize around this cause. And this makes me go to the second question that you made around the international component of this, no? And I have to say that, of course, Mariana has already highlighted that what is happening in the region has an impact, a very important impact in what is happening in Colombia. And trying to relate it with the first answer, I want to remember that, for example, in Argentina 2 years ago, 2 years and a half ago, they lost at the Congress, no, the legalization of abortion. But what they won at that moment was what we are calling today the social legalization of abortion, because with the mobilization that Argentinians made at that moment, they really create this public opinion, not only in Argentina, but this has been growing at the regional level, and that has been very important for the fights that we are giving today before the Congress and before the courts. No, that is why, for example, 2 years and a half later, Argentina has already a law at the Congress that was approved, but that is also why in Chile they have already presented a bill to legalize abortion, and that is also supporting the cause of what we are doing in Colombia. So I wanted to make the relation of those two questions, and I will let it there. Thank you so much.
So thank you, Catalina. That's super, super interesting. I think that this sort of what happens in a way is that this becomes the progressive cause. So it's something that progressives across the region has as the central issue, which is really, really very, very fascinating, the way that happened. And I think that the role of feminist organizations across the region have been really, really crucial. And also that, of course, like you were referring to, Mariana, that of course Colombian activists have been central in making it happen across the region as well. So it's not only riding the wave, but also pushing it. Ana Cristina, the last reflections from you.
Thank you, Siri. I think it's been very interesting. I was enjoying listening my colleagues with whom I've been debating all these same ideas for years, but it's like, you know, it's always a bit different. I just want to mention a couple of things about different questions you proposed here, or the participants. One thing very short is about stigma as a barrier for abortion. Of course, we've seen and we have published a couple of articles around how abortion is really a barrier for women to access legal abortion. And the idea that I mentioned in my presentation is that we've seen that stigma is intrinsically related to the crime of abortion. Even though in Colombia, abortion is a fundamental right, what persists in doctors' minds, and I'm a medical doctor, or used to be, but I also work with doctors in Colombia, is that abortion is a crime. So that is really, really a barrier that is creating barriers for women to access legal and safe services. And also conscientious objection. Catalina has experience on that conversation too, but we've been conducted now the second survey with gynecologists, OBGYNs in Colombia, and we've seen that there is a way to differentiate when a provider is really an objector or when the provider is really obstructing the services. Maybe we can talk about that later, but there are some experiences that are very interesting. Then on the international and regional movement, I would like to add two things. The first one is that we've created an environment for this conversation to go beyond or to move forward with the work we've done during the last maybe 15 years around the indications and the exceptions. Because now, today, we have much more providers that are committed with the cause of abortion, and also much more of public opinion in favor, and politicians, because the last 15 years, we really tried that those indications were implemented, not only in Colombia, in Peru, in Argentina, in Colombia. And I think that also helped with this movement that is progressing. We don't have time to talk about Central America, but that's another conversation. Then I think that from the opposition, I would also like to highlight two main arguments they've been using. One is the rights of the father, which is something that happened also in Canada 30 years ago or 40 years ago when they repeal abortion crime. And the other one is that they are trying to delegitimize the Constitutional Court as the forum for this decision. So they are trying to move the decision to the Congress because they have a majority in the Congress. And the last word I would like to say is that one of the things I strongly believe as a reason to maintain the crime of abortion is that all the legal models that we know, different from the one from Canada, for example, where they don't have a crime of abortion, all the legal regimes are structured around the protection of the fetus. And we have to change the conversation and have laws that start from the protection of women's rights, because that is in the basis. And that's why, for example, in the United States, they have been struggling with abortion, although they had in the past, let's say, happy years around access to abortion, the crime that persists in most legislations around the world, and is in the basis of the limits for women to access legal abortion. And my last work is thanks for you, Siri, and for give us the opportunity to have this webinar, and to Aniña and to Anja and all your team. It's always a pleasure to see you, although I think it's much more when we can hug each other and be in your country. So thank you, really thank you.
Thank you, Ana Cristina. Thank you so much, all of you. This has been such an interesting experience and has created so many insights and quite more questions. So I think we for sure there will be a sequel. We'll discuss these issues from different angles, and we already did have a seminar on Argentina and the abortion law in Argentina, but we'll for sure continue on this conversation. So thanks a lot. Thanks to Ana Cristina for initiating it, to Ana Cortes for organizing everything, and to the rest of the team at Judgment Forum, and to Ana Maria and Catalina and Mariana for all your insights, and to the audience for really good questions and patience with us going a bit over time. Thanks a lot.
Thank you, everyone.